This conference will now be recorded.
Thank you. I have no idea why that was on. Okay, so uh, welcome to the Fraternity Roundtable, and tonight's topic is legal relationship between Cornell and fraternities. I'm Bob Platt, the Secretary of the Alumni FC, and our second presenter is Dan Meyer, the former president of the Alumni IFC. And I want to start this talk just getting everyone to reflect 1 minute on the idea of what is a fraternity. And to me, it's a multi-generational group of Cornellians allied in a lifelong set of friendships. It accumulates and deploys assets to add value to the student experience. These assets, in many cases, are millions of dollars. It is an intergenerational gift to both pay it forward and pay it back. But it is not just a student organization. And that's really central and probably the one most important thing that I can tell you tonight. Fraternity is so much more. Just like you can't say that the law school's a student organization or the physics department's a student organization. So how are fraternity chapters organized? And there are a variety of different answers, but typically you've got a group of undergraduates who are either a separate corporation or an unincorporated association. If they're incorporated, typically they are classified as tax exempt under 501c7, and sometimes they are just undergraduates, and sometimes they include a young alumni mentoring group. Typically, this group holds few assets, but has most of the risk management challenges of the fraternity. Then, in many cases, you'll see a separate house corporation that actually owns the house. For Cornell-owned houses, this could be Cornell itself. Typically, there's also an alumni corporation. Many of the Cornell fraternity alumni corporations have 501c3 nonprofit status. And there's a complex structure usually in most houses designed to protect assets from liability in case of lawsuits. The other main idea I really want to talk to everybody and get everybody to focus on tonight is donor intent. This is really the gold standard for any discussion of philanthropic organizations. And even Cornell constantly focuses on donor intent. Certainly, when you're negotiating a gift, they're very mindful of that. But what happens after a donor dies or becomes inattentive? There's still going to be a deed of gift, perhaps a will or trust documents that will allow people to figure out what donor intent was. You know, there have been a lot of lawsuits around the country in the past decade on famous disputes over donor intent. Middlebury College, for example, had a donor who gave the money to build the chapel, and now they want to rename the chapel because allegedly the donor's family had ties to slavery. Well, that's a problem. You know, the donor gave the money with the idea that the chapel would be named after him, and you can't second guess that easily 100 years later. It leads to court cases. As cases where universities have drifted away from donor intent, advisors more and more emphasize the necessity for clear gift documents and periodic gifts over just giving a large upfront endowment gift. That way you keep as many strings as possible. So, for example, suppose your fraternity wants to endow a scholarship at Cornell. You could give, you know, a $500,000 or $1 million to Cornell, and then Cornell will spend the income from that endowment on scholarships for your students. Another approach would be to say, give that money to your national foundation and have them invest it, and then they can dole out the money each year. And of course, you're counting on them to do that and to do that as well as Cornell would do that. And you're also counting on them to have the guts to stop the stream of revenues if they feel that Cornell is not honoring the donor intent. In general, fraternities can protect themselves by diversifying. Rather than give everything to Cornell up front, spread the gifts to your Nationals Foundation or create a nonprofit for your own chapter. I'm going to give you an extremely abbreviated history of Cornell fraternities, and I don't want to run the risk of putting you all to sleep, but this is really the blood and guts of the whole situation. From the start, A.D. White opposed dorms, particularly male student dorms. He said very negative things about them. Instead, he encouraged fraternities and boarding houses. The first Cornell fraternities were founded the year of Cornell's first operation, and the first fraternity was Zeta Psi. Cornell started to grant land leases to both faculty for faculty housing and fraternities for fraternity houses to build on the perimeter of the campus. Cornell leased out land on 50-year terms, with the fraternities responsible for both paying for the construction of the house and its ongoing maintenance. But as the law school and the engineering quad were built, fraternity houses were displaced, and then Cornell built new fraternity houses for them, like, for example, Sigma Phi and Psi U and Kappa Alpha and so on. So West Campus got populated by folks that were displaced from the engineering quad, for example. What about the regulatory environment? Unlike women who were required to live in dorms, there was no residency requirement, and men, as a result, would rush down to meet trains as incoming freshmen arrived to try to get them to sign up and room at the fraternity house rather than signing up some boarding house. So there was a great competition, and that's how the word rush originated. Social control was strictly maintained by upperclassmen hazing all freshmen who had to wear beanies, and at least in the early days, female students were ignored in favor of romantic relationships with women from non-Cornell campuses. The faculty, and certainly not the small administration, rarely interfered with fraternity regulation, even in the face of pledge deaths. The status of the house was determined by the relative status was determined by contests including sports, oratory, or politics to see who hold the officer and editor positions on campus. But then from that extreme hands-off attitude, in loco parentis gradually takes hold. There was a faculty committee on student affairs that started to regulate rush, resulting in the quarter system. In the 1950s, they created a position called the Vice President for Student Affairs and a Dean of Students to assert jurisdiction over fraternities in the IFC. Later, in the 1970s, when the drinking age was raised to 21 and New York State adopted laws prohibiting alcohol at recruiting events, Cornell became more involved in regulating social events. When I was a student by 1973, there was only one assistant dean of students for fraternities and one for sororities, and now the staff is grown almost to a dozen people if you count graduate assistants and student workers. Until 2021, houses were not registered student organizations and were not subject to the campus-wide judicial system or the campus code of conduct. That changed in 2021, and now the campus code of conduct says, student code of conduct says it applies to both registered student organizations and recognized student organizations. But we still, and this is extremely important, we still have that vocabulary difference to distinguish between us and them, and both are subject to the code. There have been a series of really important external interventions in the conduct and regulation of fraternities. The first that I remember was the Saperston Commission of the 60s, where the trustees voted to force both the governing documents of local chapters and national fraternities to end de jure discrimination. Up until that time, you could read the Nationals bylaws and say, no Catholics or Jews. And when that happened and the Cornell houses couldn't get their nationals to change, the houses went local. There, however, was no disclosure of membership composition or monitoring of membership at that time. After the Res Club fire in the 1960s, life safety requirements, both sprinklers and fire escapes, were added to the recognition policy. Under President Scorton, he called upon us to reinvent pledging as we know it and limit it to just 4 weeks. Then there were two other unfortunate situations. One could say in response to some alleged incidents of intolerance, there were the 2018 presidential reforms, where each fraternity house has to file a new member plan. There has to be new live-in advisors. The officers must live in, and so on. And then in 2029, following the death of Antonio, there was an 8 p.m. curfew imposed, although at least I would argue that that was just a temporary measure. There's some other people who now claim that was a permanent measure. We will see. When COVID broke out in March of 2022, there were a number of COVID-related regulations that really forced Rush to be online only. And then there was also, with the construction of the North Campus expansion, sophomore housing requirements, which at first we were told would help us because fraternity houses were regarded as being on campus. And now we find out that sophomore boarders who are not already fraternity members can't live in. And that's just a recent irritation that was revealed. Again, I'm a lawyer, and so I love contracts. You can have oral contracts, but I swear you're much better off with written contracts. So please, please, please look at the contracts, not oral promises. And unfortunately, each house has a slightly different set of documents governing their relationship with Cornell. If you are in a Cornell-owned house, typically you will have, at the very least, a land lease or the Cornell Group Housing Plan lease documents, which are generally three-way documents between Cornell, the undergraduates, and the alumni. Some Cornell houses were forced to sign operating agreements, which are very comprehensive and one-sided documents that impose more constraints and liability on the fraternity than exists in the plain previous leases. So if there's any way you can migrate back to your lease, you're better off. The biggest difference with the operating agreements is that unlike having something like a 10 or 50 or 100-year time frame, these things, some of them require you to vacate the house on 18 months notice without cause. When a house gets suspended, typically Cornell drafts a memorandum of understanding to govern the relationship between the basic tenant house and sub-tenant, who might be another fraternity or the Cornell Residential Life Department. And there have been a wide variety of terms in those MOUs, so you have to really look very carefully for that. However, and this is the most important thing to remember, both Cornell and non-Cornell houses are governed by this thing called the recognition policy, which I contend we've spent so many millions of dollars in reliance upon, it does have contract value with us. And I'm sure that Dan could talk about that further. There are a lot of very complex relationships here. Unfortunately, it's not just the fraternity versus Cornell. There are the relationships between the local chapter and its national, the national and the North American Interfraternity Conference, who set standards for IFC, risk management rules, and so on. Obviously, Nick wants you to have your house belong to IFCs. Many nationals also require the chapter to belong to an IFC if the college has one. Cornell IFC no longer allows independent fraternities. We expelled Seal and Serpent. That happened while Travis Apgar was in charge. I don't think there's anything wrong with Seal and Serpent, but I guess Travis wanted to lean on the nationals to sort of whip the locals into shape. The Cornell recognition policy and something else called the growth policy, which is the way that Cornell goes about bringing on new chapters, require national and IFC membership for a prospective fraternity joining the campus. As a general goal, the Office of Sorority and Fraternity Life no longer has a student conduct aspect. That's the stated goal, but they can't seem to leave it. There's also this very strange relationship between the IFC and the Tri-Council. Could someone please mute themselves? The Tri-Council, which has been generally unilaterally dictated by Cornell. That's a combination of IFC, PANHEL, and the multicultural fraternal organizations. So let's just talk a brief moment about possible next steps before we turn the floor over to Dan. I really hope that we can restaff and revitalize the AIFC Standing Committee Legal Committee. And in the invite to this forum, I included a Google form that you can fill out to volunteer. I really hope that particularly if you're a lawyer, you can volunteer for this legal committee. We really have a number of very pressing legal issues, very pressing, that really needs our collective brain power and wisdom. Another piece of advice I would urge everyone to do, if you don't have one already, is draft a formal mission statement. If you have a really well-written mission statement, it can prove that you're just more than a student organization. It can also show that your purpose is something more than just drinking and partying. And these things become very important if you ever get into litigation. Collect and review copies of all of your legal documents. I'm amazed when I talk to guys from other chapters and they don't know what their legal documents are. It's important for you to have a full set, for your entire board to have a full set, because even though you hope they say nice things, you have to go back and read them periodically, make sure they do say nice things to protect you. And as I mentioned before, diversify your assets. Many of you don't know this, but as one of the presidential reforms that required in-house live-in advisors, they also set up what they call a program account for each fraternity, Cornell owned or not, where you can donate money to Cornell and then use that money to cover your live-in advisor costs or other permanent costs using Cornell's tax-deductible status, even if you're not tax exempt. Remember that national fraternities have foundations, and a lot of them have arrangements where you can establish your scholarship with them rather than Cornell. There's also the Ithaca Community Foundation. And finally, consider getting a 501c3 charity, public charity determination for your own alumni group, or maybe we should get one for the AFC so we can control funding rather than just endowing positions at OSFL like in honor of Tony Cashin and Bob Cowie, both of whom I deeply respect and admire. But why give the money to them when we can keep some control over it? The other piece of advice, and again, this isn't really a lawyer talking, but it's extremely important, is, and I think all the members of the IFC, AIFC Executive Board agree, we have to enhance our public relations. We've got to engage with our Greek trustee alumni. We've got to engage with faculty, invite them over to dinners and so on. We've got to engage with the local community. For example, now the Einhorn Center seems to be an intermediary between the goals that the nonprofits that receive the labor of students doing community service, and if there are Greeks going out there doing a service project, wear your letters, make sure that the sponsoring organization knows it's your fraternity doing it. You got acknowledged in their newsletter. We're doing this for our publicity, not for the Einhorn Center's publicity. And then issue press releases, share our successes. If you led a mission to Guatemala last summer with your undergraduates, tell everybody about it. If you've endowed a lecture, or if you've endowed a a professorship, tell everybody about it. You guys are doing great things every day, but the general public doesn't know, and as a result, this anti-Greek bias develops. And finally, please engage our alumni. I mean, we sent out a newsletter at the end of the year near reunion. I hope you guys forward the material from that to all your alumni so that they know that we're all working together, not only doing great things in individual houses, but collectively as a community. And that concludes my remarks. So what I'm going to do is I'm going to do two things. I'm going to, unless the terrible computer rebels against me completely, I'm going to go here, and God willing, I'm going to end screen sharing. I've done that. Now I'm going to turn off the recording.
This conference will now be recorded.